Alabama's new virtual ban on abortion, if it's signed into law by the governor, is certain to be challenged in federal court. And if history is any guide, it will be blocked by federal courts, lower federal courts, because it so plainly violates the constitutional right to abortion that the Supreme Court itself announced in 1973 and has reaffirmed on a couple of occasions since then. Alabama's law goes farther than most of the other abortion restrictions states have passed in recent months, in that it would ban abortion in almost every circumstance other than to save the life of the mother. In 1973 and in a couple of decisions since then, the Supreme Court says that at least before fetus is viable, that a baby could survive outside the womb, that states have really only a limited interest in limiting abortion rights. And this new Alabama law would seem to go very plainly against what the Supreme Court has previously decided. Usually, when there's a major change in constitutional interpretation, it's the Supreme Court that makes the change. So lower courts themselves feel bound by the existing Supreme Court decisions. That said, this is a case that will likely come up to the court, but no guarantee that it will be the one that the court hears. There are a lot of state laws limiting or banning or virtually banning abortion that have passed, that are being considered, and that are making their way through the court system. There are several cases already on the court's calendar for consideration. The justices could actually hear an abortion case next term, which means that they will be issuing a decision on an abortion case in the midst of the 2020 presidential campaign. This is even an issue at the moment because the composition of the court itself has changed in recent years. Justice Anthony Kennedy, who often voted to support abortion rights, usually joining with the court's liberals to do so, has retired. His place has been taken by Justice Brett Kavanaugh. He's one of two picks of President Donald Trump on the Supreme Court, and Trump, in his campaign in 2016, promised to appoint pro-life justices. So the situation at the court is very different, and there's expectation among abortion opponents and fear among abortion rights supporters that this newly conservative court will be more likely to sustain restrictions on abortion, if not get rid of the Roe v. Wade and its subsequent decision precedents altogether.